Ẹ jẹ́ ká gbàdúrà. Ọlọ́run ọba alágbára jùlọ, ẹlẹ́dàá àti alákòóso ayé òun ọ̀run, àwa ń bẹ̀ yín wípé kí ẹ wá ṣe àmọ̀ràn wa, kí àwa bá lè máa rìn ní ọ̀nà òtítọ́ pẹ̀lú ìfẹ́ àti àánú sí ara wa. Ẹ wá fún wa ní oore ọ̀fẹ́ yín kí àwa lè máa ṣe gbogbo ohun tí yóò mú ìgbéga, ìṣọ̀kan, ìfọ̀kànbalẹ̀, ìdùnnú àti àlékún àìsíkì orílẹ̀-èdè Nàìjíríà lápapọ̀ àti ìpínlẹ̀ Èkó ní pàápàá. Àmín. Ẹ káàsán èèyàn ẹlẹgbẹ́ mi, mo káàbọ̀ síbi àjíròrò tèmi. Ẹ jẹ́ ká ṣe àgbéyẹ̀wò àkọsílẹ̀ ìjíròrò èyí tí ó kọjá. Page 08, 09, page 10, page 11, I have examined the votes and proceedings of Tuesday, 11 July 2023, and approval is here granted. Iṣẹ́ tí gómìnà fi ránṣẹ́.
Olùdarí, ẹ káàsán sà, gbogbo ọmọ ilé ìgbìmọ̀ aṣòfin, ẹ káàsán sà, ẹ káàsán mà. A rí ìwé kan gbà láti ọ̀dọ̀ gómìnà tí àkọlé rẹ̀ ń jẹ́ àwọn tí gómìnà dábàá orúkọ wọn fún ìyànsípò. Mo kà á pẹ̀lú ìyọ̀ǹda olùdarí sà. Gómìnà kí gbogbo ọmọ ilé ìgbìmọ̀ aṣòfin. Wọ́n wá ní pé nípa òfin tí ó sọ wípé kí gómìnà máa dábàá láti yan èèyàn sí ipò ayẹ̀wé owó wò àgbà ní inú ìjọba ìpínlẹ̀ Èkó. Wọ́n ní ọ̀wọ́n dábàá, ọ̀wọ́n dẹ̀ fi orúkọ ọ̀gbẹ́ni Adéwuyì Mọ̀ṣúdì Adéwálé ránṣẹ́ sí ilé ìgbìmọ̀ aṣòfin fún àyẹ̀wò àti fún fífi òǹtẹ̀lù. Wọ́n dẹ̀ dúpẹ́ lọ́wọ́ olùdarí. wọ́n tún dúpẹ́ lọ́wọ́ gbogbo ilé ìgbìmọ̀ aṣòfin wọ́n dẹ̀ ní pé àwọn ń retí wípé wọ́n á tètè bá wọn dá gbé ọ̀rọ̀ náà yẹ̀wò láti fi àṣẹ sí. Ọ̀gbẹ́ni Babájídé Olúṣọlá Sanwó-Olú gómìnà ìpínlẹ̀ Èkó ni ó fi bu ọwọ́ lu ìwé náà. Olùdarí sá.
Àwọn ìfilọ̀ mìíràn.
Kò sí kankan sá.
Ìwé ìfìwọ́nú
àkòrí kan sá.
Ọ̀rọ̀ pàjáwìrì lórí àǹfààní aráàlú. Aṣòfin Isha.
Ẹ̀ka ọ̀rẹ́ olùdarí. Mo kí ẹ̀yin ẹlẹgbẹ́ mi. Olùdarí, ọ̀rọ̀ tí mo fẹ́ sọ̀rọ̀ nípa ẹ̀ ni ọ̀rọ̀ reclamation ilẹ̀ tí àwọn ará àdúgbò mi wọ́n á fi ẹ̀hónú ẹ̀ hàn sí mi pé ó lè dá àgbàrá lẹ̀ ládùúgbò wọn àti pé ó lè dá súnkẹrẹfàkẹrẹ ọkọ̀ sílẹ̀ ní gbogbo àdúgbò yìí. Àdúgbò tí mò ń sọ̀rọ̀ nípa ẹ̀ ní Parkview ní Ìkòyí. Gbogbo wa mọ̀ pé ìlú wa Èkó ilẹ̀ tí Ọlọ́run yọ̀ǹda fún wa ìwọ̀nba ni, ṣùgbọ́n gbogbo wa náà la dẹ̀ mọ̀ pé èrò pọ̀ lẹ́kọ̀ọ́ tí wọ́n ní ó tó bí 30 mílíọ̀nù èèyàn tó wà lẹ́kọ̀ọ́. Nǹkan méjì àtúmọ̀ nǹkan kẹta tún ni pé a mọ̀ pé Èkó náà ìwọ̀nba bí ẹsẹ̀ bàtà 5 ló fi jì sí orí omi. Nítorí náà ọ̀rọ̀ àgbàrá àti ọ̀rọ̀ súnkẹrẹ fàkẹrẹ mọ́tò ó jẹ́ nǹkan tí a gbọ́dọ̀ máa kíyèsí. Torí èrò tó wà lẹ́kọ̀ọ́ àti máa reclaim ilẹ̀ máa ṣe ń pè lóyìnbó ó jẹ́ nǹkan tuntun. À ń ṣe ní ẹni tó bá mọ̀ tán gbogbo alámọ̀ tán Ìkòyí VI Lẹ́kì wọ́n ti ń ṣe àwọn bàbá wa ti ń ṣe látijọ́ yìí náà. Àdèmọ̀ àwọn èyí tó sì ń tó ń ṣe lọ́wọ́ Èkó Atlantic wà ń bẹ, Orange Island wà ń bẹ, ìkànnà tó wà ní Gravitas tó wà káàkiri ṣùgbọ́n gbogbo bí tó ń ṣe yẹn wọ́n ń ṣe bó ti tọ́ bó dẹ̀ ti yẹ ni wọ́n ń ṣe. Ní àsìkò yìí náà a dẹ̀ mọ̀ pé iléeṣẹ́ ìjọba tó wà fún tó ń sọ ń pa ìlà tí ń pè náà ojú ọjọ́ ó ti ní ká kíyèsí pé òjò tó máa rọ̀ lọ́dún yìí ó pọ̀ pẹ̀lú ojú ọjọ́ tó yí padà tó ń pè ní climate change. Òjò ń rọ̀ sí ó tún lékún ní lọ́dọọdún. Sọ̀rọ̀ òjò ó ṣe nǹkan tí a lè mú fọwọ́n mú dání. Nítorí yìí ni ó ṣe jẹ́ pé ẹnikẹ́ni tó bá fẹ́ reclaim ilẹ̀ nǹkan méjì ló máa ń sábà béèrè lọ́wọ́ ẹ̀. Ìkan wọ́n pè ní environmental impact assessment, ìkejì traffic impact assessment. Ìkòyí omi méjì ló wà ní apá ọ̀tún àtòsí fún Ìkòyí. Gbogbo a la mọ̀ pé island ni. Lọ́wọ́ sàlẹ̀ a ní èyí tá ń pè ní 5 Cowrie Creek. Lọ́wọ́ òkè a ní èyí tá ń pè ní Lagos Lagoon. Láti Awolowo Road dé Bodilon Oyinkan Abayomi Alexandra Avenue omi òjò àti omi tó ń lò nílé ó dà sínú 5 Cowrie Creek. Tabasu síwájú Gerald Parkview nínú Banana Osborn 1 Osborn 2 Ìkòyí Crescent títí lọ síwájú àwọn yẹn dà sínú Lagos Lagoon. Gbogbo nínú Parkview ìdá 4 nínú ìdá 5 omi wọn ó ń gba títí Olúṣẹ́gun Àìná àti Professor Jubril Aminu ló ń gbàdá sínú Lagos Lagoon. Lagos Lagoon yẹn ní ibi tó tẹ̀ tí ń dà yẹn ó torí bí a ṣe súnmọ́ omi bí ilẹ̀ wa ṣe súnmọ́ omi tó ó ní nǹkan tó ń pè buffer zone tó máa mú omi yẹn dání tó máa fi ṣọ̀lọ. àwọn tó ń gbé lórí títì méjèèjì yẹn wọ́n fi ìhànú hàn mí, wọ́n ti pè mí lọ́tún lósì pé wọ́n reclaim ilẹ̀ ní ibi tí buffer zone yẹn wà àti gbogbo àyíká ibẹ̀ yẹn. ìtumọ̀ ẹ̀ ni pé omi tó ń bọ̀ láti gbogbo Gerald tó máa dà sínú Lagos Lagoon yẹn ọ̀nà tó yẹ kó gbà ó ti dínkù. àwọn kan náà ti reclaim bìkan, ẹnìkan ṣe títì sórí gọ́tà tó yẹ kó máa gbómi lọ, wọ́n ṣáà ti ṣe gbẹ̀gbẹ̀ yẹn báṣu. mo dẹ̀ lọ síbẹ̀ fúnra mi, mo lọ wò. nígbà tí màá tẹ̀tù débẹ̀ mo tún rí i pé ní apá kejì omi yẹn tó jẹ́ pé òun ni banana, ẹnìkan náà tún ti ń reclaim lẹ̀bọ̀ tó tún ti jẹ́ kí àyè ibi tó yẹ kó mi máa dúró sí yẹn kó tún kéré ju bó ṣe yẹ lọ. ọ̀gá olùdarí, ní ilé ìgbìmọ̀ aṣòfin tí a ṣẹ̀ṣẹ̀ tán yìí mo wà ní inú ìgbìmọ̀ waterfront. a rí nǹkan kan tó jọ nípa reclamation yìí nínú committee. mo wà nínú ìgbìmọ̀ public private partnership náà, a rí nǹkan kan tó jọ reclamation yìí nínú ìwé wa. alhamdulilayi ọlá yín, mo jẹ́ chairman ìṣúná owó ní last assembly náà. àdèmá ní kọ́ mú kọ̀ọ̀kan méjì wá, gbogbo MDs pátá ló máa mú wá. à ń pè kan ní project brief, à ń pè kejì ní project status report. project brief yẹn gbogbo iṣẹ́ tí iléeṣẹ́ yẹn bá ń ṣe, iléeṣẹ́ ìjọba yẹn bá ń ṣe pátá tó jẹ́ tuntun wọ́n máa kọ́ ń pa ẹ̀. wọ́n bẹ̀rẹ̀ ni wọ́n ti fi sínú bọ́jẹ̀tì wọn, wọ́n máa kọ́. gbogbo iṣẹ́ tó ń lọ lọ́wọ́ náà wọ́n máa kọ́. àbápàdé yálà lands ní o, waterfront ní o, PPP ní o, new towns development ní o, àbá iṣẹ́ yẹn pàdé rárá. nítorí náà iṣẹ́ yìí fẹ́mi ooru mi lójú, ìkòdà ń péjọba mọ̀ pa ẹ̀. olùdarí, nǹkan tí mo fẹ́ bẹ̀yìn fún ni pé kẹgbà wá, kẹtọ́ wá sọ́nà. ẹ mọ̀ pé ẹ̀yin ògbóǹtarìgì aṣòfin ní ẹ̀yin ni àwọn olóyìnbó ń pè ní Methuselah of our noble house yìí. kẹgbà wá nímọ̀ràn ní orí bí orú kìíní tó máa dá súnkẹrẹ fàkẹrẹ lẹ̀ ládùúgbò, tó máa di omíyalé àgbàrá ya ṣọ́ọ̀bù ládùúgbò, tó tún máa jẹ́ pé ó tún máa kó bá ojú títì. torí ọ̀rọ̀ súnkẹrẹ fàkẹrẹ yìí tí wọ́n bá kọ́ bẹ̀ tán àwọn èèyàn náà lọ máa gbé bẹ̀, wọ́n máa ní mọ́tò. gbogbo parkview yẹn ń sìn Gerard ló ń bọ̀ lọ́ máa gbà jáde tó mú Osborne, gbogbo àwọn mọ́tò yẹn inú ọ̀nà tó jẹ́ pé bó ṣe wà ń sìn gan gbósùlù máa wà bẹ́ẹ̀ láàárọ̀, ó máa wà bẹ́ẹ̀ ní alẹ́. ìyẹn náà tún dákun. ìyẹn ni mo ní kí n mú wá sí ilé lẹ́nu pé kẹgbà wá nímọ̀ràn ní orí nǹkan tá a máa ṣe. ẹ ṣe pọ̀.
ta ni o tún fẹ́ gbé wọ́n ní aṣòfin Olúmọ?
ẹ ṣe olùdarí, mo kàn fẹ́ dá sí ọ̀rọ̀ tí honourable Ishao àmì aṣòfin Ishao tí wọ́n sọ ní àárọ̀ yìí. nítorí wọ́n ṣe gbé kalẹ̀ ó jẹ́ nǹkan tí ó ní agbára púpọ̀, bẹ́ẹ̀ jùlọ àsìkò tá a wà yìí àsìkò òjò ni. ilẹ̀ tó dẹ̀ ń sọ̀rọ̀ nípa ẹ̀ yìí ó di dandan, ó dẹ̀ da kí ìgbìmọ̀ ilé aṣòfin yìí ká ṣègbésẹ̀ tó yantanran lórí ẹ̀. ibẹ̀ yẹn nìkan kọ́, àtúrà àwọn bòmíì tí wọ́n tún ṣe orú nǹkan báyìí káàkiri. bẹ́ẹ̀ bá dé sáìdì àgbádárìgì mọ́ àmúwò ọ̀dọ̀fin, gbogbo ẹ̀ náà ló tún ṣẹlẹ̀ ń bẹ̀. èmi ò mọ̀ bóyá ìjọba mọ̀ sí àbí wọn ò mọ̀ sí. ẹlẹ́ẹ̀kẹta nínú ọ̀rọ̀ mi ni wípé wọ́n bá tiẹ̀ mọ̀ sí kílẹ̀ tó ìjọba nínú kínní, ṣé wọ́n ń ṣe àbọ̀ ń ṣe? àwọn ni tí wọ́n ń ṣe ṣé wọ́n ń ṣe ẹ̀tọ́ fún ìjọba? èmi ò rò wípé wọ́n ń ṣe. torí ẹ̀ mo fẹ́ kún aṣòfin Ishao lẹ́yìn wípé kẹjọ kẹgbé ìgbìmọ̀ tó bá lágbára lórí ọ̀rọ̀ yìí ká bá lè ṣèwádìí, torí gbígbé àwọn ará ìpínlẹ̀ Èkó ó jẹ́ nǹkan tí mo mọ̀ kó jẹ yín lógún púpọ̀ jù. Ẹ ṣeun olùdarí.
Ẹ ṣé olùdarí, èmi náà fẹ́ dá sí nǹkan tí aṣòfin ishao tó wọ́n sọ, torí kí mo tó jẹ igbákejì olórí ọmọ ẹgbẹ́ tó pọ̀ jùlọ, èmi náà ní àǹfààní láti pàṣẹ yín láti jẹ́ alákòóso ti committee lands. Èmi náà dẹ̀ rò pé nínú gbogbo bá ṣe ń ṣe ìyẹ̀wò iṣẹ́ wọn àti gbogbo nǹkan tí wọ́n mú wá sí iwájú wa, mi ò rò pé a bá pàdé nínú gbogbo iṣẹ́ tí a ṣe. Ó túmọ̀ sí pé iṣẹ́ tí wọ́n gbé wá síwájú wa yìí, pé iṣẹ́ tí ìjọba lóòótọ́ wọ́n lè máa mọ̀ nípa ẹ̀. Ọ̀rọ̀ tí fẹ́ sọ ó wá kọ̀ fẹ́ farapẹ́ nǹkan tí Honorable aṣòfin Olúmọ tí wọ́n sọ, pé kí olùdarí kó fi àsìkò yìí kó wò pé gbogbo àwọn èèyàn tí wọ́n gbé ní agbègbè yẹn fún àǹfààní wọn níwájú, pé kí olùdarí wo ìgbìmọ̀ alábẹ́sẹ́kẹ́lé tí ó lè wo gbogbo èmi ní nǹkan tó farapẹ́ ọ̀rọ̀ omi reclamation nǹkan tí Honorable Ishao dárúkọ, láti lè jẹ́ kí gbogbo nǹkan tí ó máa fa súnkẹrẹ fàkẹrẹ ní gbogbo agbègbè yẹn kó tún dínkù ní sáà tí a mú yìí. Ẹ ṣé púpọ̀ olùdarí.
Aṣòfin Miranda.
Ẹ ṣé olùdarí, ọ̀rọ̀ tí mo máa fẹ́ dá sí ọ̀rọ̀ tí aṣòfin Ishao gbé kalẹ̀ láàárọ̀ yìí, nítorí tá bá wò omi jẹ́ nǹkan tó ń dẹ́rù bàyàn. Tá bá sọ àwọn kùdìẹ̀kudiẹ tí irú ọ̀rọ̀ tó gbé kalẹ̀ yìí lè fà, kódà ọ̀rọ̀ súnkẹrẹ fàkẹrẹ mọ́tò ó tún kéré nù nǹkan tí ọ̀rọ̀ oní reclamation yìí lè bàjẹ́. Olùdarí, màá rọ̀ yín kẹ́ ṣe àgbékalẹ̀ ìgbìmọ̀ alábẹ́sẹ́kẹ́lé ti ilé tó máa lè kọ̀wé sí àwọn ministries tó likely kó wà involved nínú gbogbo kìíní, bíi physical planning, waterfront, environment àti pàápàá jùlọ land, because mo nígbàgbọ́ pé bí ò tiẹ̀ sí commissioner bẹ́ẹ̀, àwọn òṣìṣẹ́ ìjọba tó wà ń bẹ̀ látòrí permanent secretary àtàwọn directors tó jẹ́ ojúṣe wọn kọ́tẹ̀ wá sọ fún ilé yìí, ṣé environment ni o, wọ́n ní environmental impact assessment gbogbo reclamation yìí, kí ni role ti waterfront, kí ni ìgbésẹ̀ ti waterfront gbé, kí ni ìgbésẹ̀ physical planning, ta ló fún àwọn tó ń ṣe reclamation yìí láṣẹ láti bẹ̀rẹ̀ iṣẹ́ wọn. And as a matter of urgency, kọ́tí ẹ̀ kọ́kọ́ lọ stop wọn, kọ́ dá gbogbo reclamation tó bá ń ṣe níbẹ̀ dúró ní báyìí. Ẹ ṣé olùdarí.
Aṣòfin Ṣẹ̀tọ́njú.
Ẹ ṣé olùdarí, ọ̀rọ̀ kàbìtì tí Honorable Ishao gbélẹ̀ yìí ó jẹ́ kan tí ó ṣe pàtàkì púpọ̀ jù, torí pé Èkó, Lagos State, a wà ní below street level gẹ́gẹ́ bí àwọn òyìnbó ṣe máa ń sọ. So
kì í ṣe ọ̀dọ̀ wọn nìkan ní ìdààmú yìí wà ní ọ̀dọ̀ wa náà ní Badagry kan tí òjò ti dálẹ̀ omi ti wọlé káàkiri nítorí pé bá ṣe ń kọ́lé àkè rántí pé tójò bá rọ̀ omi ẹ̀ máa rí ibi kan gbà ó dùn jẹ́ nǹkan tí ó fún wa ní problem púpọ̀ jù especially nípa Ministry of Environment àwọn canal tó yẹ kán kó tó ti block káàkiri wọn ò kó wọn so báwo yẹn lè ṣe ń kọ́lé sí àwọn ẹ̀lẹ́dílẹ̀ lẹ́kọ̀ọ́ ilẹ̀ wọn bá tá a ní náà bó ṣe ń kọ́ ní ibi tí omi máa gbà wọn ò fa yí ẹ lẹ̀ nítorí ẹ̀ ní bó fẹ́ fi rọ olùdarí pé kọ́ jọ ọ̀rọ̀ yìí ṣe pàtàkì púpọ̀ jù kó tó di pé omi gbé wa lọ nítorí pé ìdààmú tó tí ọ̀rọ̀ omi yìí fún wa ní àdúgbò wa kì í ṣe kékeré màá fẹ́ bẹ̀ yín sà kí ẹjọ́ ká jẹ́ kí Ministry of Environment kọ́ ṣiṣẹ́ wọn gẹ́gẹ́ bí iṣẹ́ especially ibi tí ẹ̀kọ́ di kó canal káàkiri canal ti block so omi ti wá ya sí gbogbo ìlú so wọn bá tí mo rí sọ sí ọ̀rọ̀ tó wà lẹ́yìn ẹ̀ ṣe sà.
aṣòfin Ògúnkẹ́lú.
ẹ ṣe olùdarí ẹlẹgbẹ́ ibi tí aṣòfin ìṣàwò sọ yìí ó jẹ́ ibi tí ẹ pé èmi náà mo ṣara sí ibẹ̀ mo rí pé ká tó rí bíi ọdún kan àbóṣù mélòó ń sìn ibẹ̀ ti wà lórí afẹ́fẹ́ pé wọ́n fẹ́ tà àǹtí abádẹ̀ wo íńtánẹ́ẹ̀tì dáadáa ń sìn a rí i pé wọ́n ti ń ṣe advert pé ibẹ̀ yẹn ti wà pé wọ́n fẹ́ tà tábàdẹ̀ tó fẹ́ tà ohun tèmi máa gba inú ilé aṣòfin ni pé ká wádìí àwọn tó fẹ́ tà bí àtàbá yan wọn bíi ìgbìmọ̀ kékeré ká lè fi wádìí àwọn tó ń tà fún àtẹni tó fẹ́ tà yẹn la lè fi mọ̀ láti lè bá wọn sọ̀rọ̀ ẹ ṣe ń gọ́sà.
aṣòfin Bólú.
kábíyèsí olúwàbí
láàfin Ọ̀yọ́ àbí àbọ̀dọ̀ Akíolú.
olùdarí àgbà ẹ ṣe gan sa mo dúpẹ́ lọ́wọ́ aṣòfin Ishawu fún àgbékalẹ̀ ọ̀rọ̀ tí à ń sọ lọ́wọ́ èmi gan ní ọ̀dọ̀ mi ní Badagry ní constituency mi a nírú ìṣẹ̀lẹ̀ bẹ́ẹ̀ yẹn mo lérò pé tá bá bọ́ sórí social media àwọn ọmọ ti pariwo ní Badagry mo wá gbéra mo lọ bá alága ìbílẹ̀ méjèèjì tó jẹ́ àbójútó ibẹ̀ yẹn a dẹ̀ wá sí Ministry of Waterfront ṣùgbọ́n agbára wa ò ká torí ibi tó ti ń gbọ́n yẹ̀pẹ̀ lọ́wọ́lọ́wọ́ ẹgbẹ́ bridge ẹyọ kan tó so Badagry West tó jẹ́ ìlú bọ́dà àti Badagry town gangan ibẹ̀ yẹn náà ti gbọ́n yẹ̀pẹ̀ yẹn lọ́wọ́ a ti pariwo tó mo dẹ̀ wá dúpẹ́ fọlọ́run pé aṣòfin àgbà Ishawu wọn gbé ọ̀rọ̀ yìí kalẹ̀ mo máa rọ̀ yín sà pé kí Badagry ní ẹgbẹ́ bridge yẹn torí lọ́wọ́lọ́wọ́ bí mo ṣe ń bá yín sọ̀rọ̀ sà ní àárọ̀ yìí $1 million mo kó kalẹ̀ torí opposite ẹ̀ di village mi omi ti gbé àwọn èèyàn mi lọ gbogbo inú ilé omi ti wọbẹ̀ mo láti gbówó kalẹ̀ pé kán lọ gbẹ́ gọ́tà so that omi máa lè lọ ṣùgbọ́n omi yẹn ò lọ torí ìyẹ̀pẹ̀ tó ń gbọ́n bẹ̀ wọ́n dẹ̀ fi ń ṣòwò ni wọ́n ń tà ni so ńgbà tó dẹ̀ ti wá gbé ọ̀rọ̀ yìí kalẹ̀ ń sì máa rọ̀ yín sà pé kí ẹ bá wa consider Badagry nínú ọ̀rọ̀ yìí ẹ ṣé sà.
aṣòfin Lára. no bó paná ọ̀nà
ẹ káàsán olùdarí ọ̀rọ̀ pa nǹkan tí aṣòfin Ishawu sọ ọ̀dọ̀ mi ní Lagos Island a mọ̀ pé ibẹ̀ ni àwọn èèyàn púpọ̀ máa ń pè ní ilé owó Èkó because kò sí nǹkan tẹ́ máa wá sí ọ̀dọ̀ wa níbẹ̀ yẹn tẹ́ ẹ̀ lè ríra gbogbo ibi títí ọ̀dọ̀ wa mọ́ ọ̀rọ̀ yìí a ní drainage problem gbogbo ibẹ̀ yẹn pátá àwọn èèyàn ti bà lé jẹ́ ó ti bà businesses àwọn èèyàn jẹ́ tó bá máa débẹ̀ yẹn tó bá máa rìn débẹ̀ báyìí mo lọ ní last weekend lọ sínú ọjà omi yẹn ibi ẹsẹ̀ mi orúnkún mi ó kọjá bẹ̀ mo láti máa fa kódà àwọn èèyàn kan ti bẹ̀rẹ̀ business lẹ́yìn pé wọ́n fún wọn raincoat tó bá fẹ́ lọ sínú ọjà bó ṣe ń sìn nìyẹn so mo ò mọ nǹkan tí ó ń go on nípa ẹ̀ wọ́n sọ pé physical planning bóyá máa ṣe nǹkan wọn pẹ̀lú lùbìrín estate tó ń kọ́ síwájú ọ̀dọ̀ wa níbẹ̀ but a ti try mo ti ṣe findings mi ní pé kí n wo gbogbo ìgbésẹ̀ tabalégbé then lórí ọ̀rọ̀ tí aṣòfin ṣàwùsọ láàárọ̀ yìí ìgbà tẹ́mi ń bọ̀ láti lé sí ọ̀dọ̀ ibi tẹ́mi ti ń bọ̀ wá síbí báyìí sí about 1 hour nínú 1 hour yẹn lórí Ìkòyí link bridge lásán 30 minutes 35 la ló ń bẹ lórí ọ̀rọ̀ súnkẹrẹ fàkẹrẹ so Parkview mọ́ Banana Island ọtí ń fi lómi yẹn bọ̀ wọnú lagoon traffic wà ń bẹ àwọn èèyàn wò ó pé kí ló fà Fálọmọ bridge dé Ozumba free road but ibi tó súnmọ́ ibi táwọn èèyàn ti ń bọ̀ gangan ní Lekki Ìkòyí link bridge yẹn ẹ̀dẹ̀ ńlá ti gba wájú Parkview tẹ́ bá fẹ́ lọ link third mainland bridge so téèyàn bá lo 35 minutes lórí ibẹ̀ yẹn pé mo ò dẹ̀ pẹ́ tó yẹn lórí third mainland bridge tí máa fi dé ibiṣẹ́ kí ni reason tí ó ṣe ń ṣẹlẹ̀ bẹ́ẹ̀ àwọn wo ló wà ní charge àwọn wo ló ń tabẹ̀ àwọn wo ló fún wọn permission láti ṣe because mo rò ó pé common resource wa bá ṣe mọ̀ pé kò is our landmine and value for Lagos is our land ilẹ̀ wa dẹ̀ ní nǹkan tó yẹ kí a dìmú kọ́ tó sọ pé ó fẹ́ ṣẹlẹ̀ ó fẹ́ gbalẹ̀ padà láti orí omi reclamation tá à ń pè ó máa gba permit ta ló fún wọn permit tó fi fi ilẹ̀ tán àwọn èèyàn ń rìn à ń rìn látòrí bridge tá a bá dúró sórí Lekki bridge à ń rìn bó ṣe ń fi lómi yẹn wọnú kò dìgbà tómi bá gbé wa lọ kò dìgbà tómi bá gbá àwọn constituent wa lọ ká tó dìde ṣe nǹkan tó jẹ́ ká ṣe mo tọrọ lọ́wọ́ ilé yìí kó fún wa láyè kó dẹ̀ pé gbogbo àwọn tó bá wà ní charge gbogbo kìíní yẹn with immediate effect sir thank you very much.
ọjọ́ yorùbá là ń sọ ọjọ́ yorùbá dẹ̀ máa sọ òyìnbó
ẹ má bínú sá.
aṣòfin Tèmítọ́pẹ́ ọkọ̀ aṣòfin Músíbà.
Yes sir. Olùdarí a dúpẹ́ púpọ̀ ní ọwọ́ yín òye àti làákàyè tí Ọlọ́run fún yín kò ní kúrú sà ní gẹ́gẹ́ bí ọ̀rọ̀ tí aṣòfin Ishao tí wọ́n mú wá sí etí ìgbọ́ wa ní ilé ìgbìmọ̀ aṣòfin yìí ọ̀rọ̀ tó ṣe kókó jù tó dẹ̀ jẹ́ pàtàkì ni àwọn aṣòfin tó kù náà dẹ̀ ti sọ ọ̀rọ̀ púpọ̀ lórí ọ̀rọ̀ wípé à ń gba ilẹ̀ padà láti inú omi àmọ́ tèmi náà fẹ́ fi kún nínú ọ̀rọ̀ yìí ojú wípé nípa omi jalè àgbàrá ya ṣọ́ọ̀bù yìí ó káàkiri àwọn ìbílẹ̀ tó súnmọ́ omi ní ìlú Èkó ń bí igbákejì olùdarí wa ti wá mú àbá wá láti jẹ́ wípé kí wọ́n pe àwọn tí wọ́n jẹ́ alákòóso àwọn mínísírì wọ̀nyí gẹ́gẹ́ bí lands physical planning waterfront and environment èmi náà wá mú wá láti gbé wọn lẹ́sẹ̀ wípé kí wọ́n gbé ìgbésẹ̀ láti lè yan àwọn ìgbìmọ̀ kékeré láti lè jẹ́ kí àwọn olùdarí mínísírì wọ̀nyí kí wọ́n wá ṣàlàyé bí ọ̀rọ̀ yìí ṣe jẹ́ mo dúró báyìí.
aṣòfin Ìkòròdú.
Ẹ ṣé olùdarí, orúkọ mi ni aṣòfin Àrò Moshood Abíọ́dún olùdarí. Mo kí gbogbo ọmọlé ìgbìmọ̀ aṣòfin ìpínlẹ̀
Ìkòròdú kọ́ ló sọ.
Ìkòròdú ẹkùn kejì sà. Olùdarí àti gbogbo ọmọ ẹgbẹ́ ilé ìgbìmọ̀ aṣòfin, mo fẹ́ kí gbogbo àmọ̀ pé ibi tí amòfin Ìṣàwò tó ń sọ̀rọ̀ nípa èyí kójú ò má rọ̀ rárá, ilẹ̀ omi ni. Tó bá tún wá di pé ibi tó yẹ kómi tún máa gbà láti mú kí ìdẹ̀rùn dé bá àwọn aráàlú, àwọn kan tún fẹ́ díbẹ̀ pa, a rí pé ṣe ló ń gbèrò pé kí omi gbé àwọn ọmọ ìpínlẹ̀ Èkó lọ. So olùdarí àti gbogbo ẹgbẹ́ ilé ìgbìmọ̀ aṣòfin, mo fẹ́ kí ká tètè kóra wa jọ láti tètè gbé ìgbésẹ̀ tó nípọn lórí ọ̀rọ̀ yìí kó tó di pé àwọn èèyàn á bẹ̀rẹ̀ sí ń pariwo pé omi gbé wọn lọ. Ẹ ṣé olùdarí.
Aṣòfin Àjàyí.
Olùdarí, mo kí lẹ́ẹ̀kan sí pé ẹ kú dédé àsìkò yìí, Ọlọ́run àbá máa dúró tì ẹ ṣe gan. Mo dẹ̀ kí àwọn aṣòfin ẹlẹgbẹ́ mi tó kù náà wípé kọ́ kú dédé àsìkò yìí. Aṣòfin Ìṣàwò wọ́n ti sọ̀rọ̀, inú mi dẹ̀ dùn wípé gbogbo ọ̀rọ̀ tí wọ́n sọ yìí ó jẹ mọ́ ètò wá láti agbègbè tèmi. Olùdarí sà, ó kù díẹ̀ ká ṣe iléyá, ètò ìṣẹ̀lẹ̀ ládùúgbò wa kò ṣe fẹnu sọ. Láti ibi DC port dé ìlú kan tí wọ́n pè ní Àkọ́dó Ìṣẹ̀ kò ṣe wọ̀ rárá. Ìpè yìí pọ̀ gan, ṣùgbọ́n mo dúpẹ́ pé àti bẹ̀rẹ̀ iṣẹ́ ilé ìta ṣe lọ́jọ́ òní táṣì rí bá máa tú pé kò ṣe nǹkan kan fún wa. Mò ń jẹ́ kọ́ mọ̀ pé àti bẹ̀rẹ̀ iṣẹ́ kò sí nǹkan láà lè ṣe, ṣùgbọ́n àwọn tá a lè pè lásìkò ẹ̀ náà á pè wọ́n. Mo wá dúpẹ́ lọ́wọ́ chairman LCDA wa ń gbà yẹn, ó lọ gba katakata, ó lọ bẹ̀ sí ńlá ọ̀nà ẹ̀sùn oko láti lè rí pé kínní. Ṣùgbọ́n àkíyèsí kan mo fẹ́ yá bàrà láti pè wá sísà ní ọ̀dọ̀ tiwa lọ́wọ́ tó ń ṣẹlẹ̀. Ìwádìí tẹ fẹ́ ṣe ni sínú nǹkan yìí, mo fẹ́ kẹ́ bá a fi sínú ẹ̀. Mo fẹ́ kẹ́ bá wa pe àkíyèsí àwọn lands, àwọn tó ń ṣètò ilẹ̀ ní ìpínlẹ̀ Èkó, àwọn tí wọ́n fún ní estate yóò ti ń pọ̀ jù ládùúgbò wa, àwọn ló ń ṣe kíní tá à ń ṣe yìí. Ètò ti ṣẹlẹ̀ lọ́dọ̀ àwọn ọ̀nàrẹ́bí Ìṣàwò, ó ti pẹ́, ọwọ́ ọ̀ka mọ́ ló ń fa ilé yìí. Ètò ọwọ́ ìdèkà lọ́la òun lè dúró sọ̀rọ̀ ń pa yìí. Ẹ sà, mo máa bẹ̀ yín ni sà, ẹ bá wa pe àwọn ará bíi kọ́ máa estate ní àdúgbò wa ní Ìbẹ̀jú Lẹ́kí, kọ́ jọ kọ́ bá wa máa ṣe díẹ̀díẹ̀, iléeṣẹ́ là ń fẹ́. Ẹ ṣé sà.
Aṣòfin Jubrila.
wọ́n máa kún yín lọ́wọ́. ọ̀rọ̀ tí ó wà nílẹ̀ yìí ojú méjì ni mo fẹ́ kẹ́ jẹ́ kí a fi wò ó. ojú kìíní ni nǹkan tí a lè tètè ṣe tí àwọn aṣíwájú mi ti ń sọ. ojú kejì ni nǹkan tó jẹ́ ọjọ́ iwájú. ìtẹ́mi fẹ́ sọ yìí ó jẹ́ mọ́ ọjọ́ iwájú tí mo rò yí pé tí ẹ̀yin adarí wa àti àwọn ọ̀jọ̀gbọ́n bá fojú inú wò wọ́n á rí i pé a ṣe wá láǹfààní.
kẹ́ bá ṣe mọ̀ yí pé àwọn agbègbè tí wọ́n ń sọ yìí omi ń pọ̀ tó ń dà wọ́n láàmú ó dẹ̀ ń fa súnkẹrẹ fàkẹrẹ ọkọ̀ èmi á rọ̀ wá yí pé tí àwọn Ministry of Lands àti Physical Planning tí wọ́n bá lè bá gbé òfin láti lè máa jẹ́ kí àwọn tó bá fẹ́ kọ́lé sí agbègbè yìí kí irú ilé tó máa kọ́ tí ò ní máa gba èèyàn púpọ̀ sódà tí pé a máa jẹ́ kí àwọn súnkẹrẹ fàkẹrẹ agbègbè yẹn a máa dínkù àwọn agbègbè tó bá ṣe pé kò lè sí irú ọ̀pọ̀lọpọ̀ nǹkan bẹ́ẹ̀ yẹn wọ́n lè gbà pé wọ́n máa kọ́ àwọn ilé ńláńlá síbẹ̀ èmi rò pé irú nǹkan báyìí a tún ṣe àǹfààní fún ìlú Èkó mo dúró níbí náà sà.
aṣòfin Ògúndípẹ̀.
lẹ́ẹ̀kan sí ẹṣẹ́ olùdarí inú mi dẹ̀ dùn pé ọ̀rọ̀ tó jẹ́ àwọn aráàlú lógún pàápàá jùlọ ibi tí èmi ti wá tí mo dẹ̀ rí wípé oríṣiríṣi nǹkan náà ti ṣẹlẹ̀ lórí ọ̀rọ̀ omi tẹ́ bá wo láti Ìkẹjà olùdarí gbogbo ilé tó wà nínú GRA tí òjò bá rọ̀ pẹ́rẹ́ kò sí àǹfààní ibi tí àwọn omi yẹn máa gbà ju kó yá sí ojú pópó láti Òṣòdì lọ sí ọ̀nà Agége tó fi mú gbogbo Ṣógúnlẹ̀ ní ìlú Ṣógúnlẹ̀ eléyìí ti jẹ́ nǹkan tó ń kọ́ wá lóminú torí púpọ̀ nínú àwọn ọmọléèwé wa omi ẹ̀gbọ́n máa ń wọ́ wọn lọ tó wá fi lè rọ̀ torí ìjọba tún ṣe ọ̀nà sí Ṣógúnlẹ̀ ẹni tó tiẹ̀ tún wá ṣe ọ̀nà yẹn pàápàá tẹ́ bá lọ síbẹ̀ ń sìn ṣe ó dàbí pé wọn ò ṣe ọ̀nà rárá torí pé omi tó ń jáde láti GRA sí Ìkẹjà tó ń wọ ìlú Ṣógúnlẹ̀ ṣe ló máa ń wọ gbogbo ọ̀nà tó bá ti ṣe lọ ọ̀nà yẹn ò dẹ̀ tí ju ọdún méjì tí ìjọba ṣe lọ ṣùgbọ́n tẹ́ bá débẹ̀ ṣe ló dàbí abúlé sí torí kò sí ọ̀dà tí wọ́n ṣe sójú títì tẹ́ bá dẹ̀ wá wo ọ̀nà airport náà mo rò pé wọ́n ti ẹ̀ gbìyànjú àwọn tó ń kó canal wọ́n gbìyànjú torí pé wọ́n pè wọ́n dẹ̀ dúpẹ́ gan pé ní ọdún yìí nìkan làwọn ti di pé ọ̀rọ̀ mi ó wà wọ́n díẹ̀ sílẹ̀ sórí darí èmi náà fẹ́ fi ohùn sí ọgbọ́n tí àwọn ẹlẹgbẹ́ mi ti sọ ń bí wípé Èkó láti jígìrì aláti dìde láti jẹ́ kọ́ mọ̀ wípé iṣẹ́ òjò tó bá ti rọ̀ tó dẹ̀ máa ń gbọ́ wípé wọ́n sọ fún wa pé ètò ti wà ńlẹ̀ pé kí èèyàn máa fòyà ṣùgbọ́n a rí pé tójò bá bẹ̀rẹ̀ náà ìfòyà ńlá sì wà pàápàá jùlọ fún àwọn mẹ̀kúnnù tí wọ́n ń gbé gbogbo agbègbè tí mo sọ yìí so mo fẹ́ bẹ̀ wá mo fẹ́ rọ̀ wá ni pé gbogbo àwọn tí wọ́n ń ṣe iṣẹ́ tó rọ̀ mọ́ ọ̀rọ̀ omi láti jẹ́ kí iléeṣẹ́ wa aláṣẹ jẹ́ kí gbogbo wọn kàn jókòó papọ̀ wọ́n dẹ̀ rí wípé ọ̀nà wo ló fẹ́ gbé gbà tí a máa fi dẹ́kun àwọn ọba láti wà nílẹ̀ yìí ẹ ṣe olùdarí.
ẹ ti jẹ́ kí a máa da àwọn kìíní pọ̀ mọ́ ara wọn ọ̀tọ̀ ọ̀rọ̀ omíyalé agbára yosò ọ̀tọ̀ lọ̀rọ̀ àwọn tí ó ń dí lílọ omi láti lè sọ odò di ilẹ̀ ẹ má jẹ́ ká rú méjèèjì pọ̀ kó lè níyànjú agbègbè tí ìṣòro àgbàrá bá wà a lè ṣe yẹ lọ́tọ̀ èyí táwọn ń sọ yìí tí aṣòfin Ishau mú wáyé ó yàtọ̀ sí ọ̀rọ̀ àgbàrá ya òyàlé àti ibi tí iṣẹ́ tán ti ṣe tẹ́lẹ̀ tí kò dúró déédéé ṣùgbọ́n ìtàn mú wá láàárọ̀ yìí bí a ṣe láti ṣe àkíyèsí àwọn tí wọ́n sọ omi di ilẹ̀ tó dẹ̀ di àwọn aráàlú ní ọwọ́ àti agbègbè tó kù ìyẹn ni ìtọ́jẹ́ gbogbo nítorí ìdí ìyàwó tájá àdúgbò wọ́n wá iyanrìn láti fi dí odò kó lè dilẹ̀ àwọn yẹn ní ọ̀rọ̀ yìí ní lókàn. Aṣòfin Ẹ̀gẹ́.
mo dúpẹ́ gan lọ́wọ́ yín olùdarí ẹ pẹ́ fún wa o orúkọ mi ni Ẹ̀gẹ́ Olúṣẹ́gun Adébísí tí mò ń ṣe aṣojú Ọ̀jọ́ constituency 1 olúwa mi lórí ọ̀rọ̀ tí aṣòfin Honorable Ishau gbé kalẹ̀ mo fẹ́ sọ pé lórí ọ̀rọ̀ omi ó jẹ́ nǹkan pàtàkì tá a gbọ́dọ̀ gbé ṣeré sà ọ máa ń sọ pé Èkó ló lòkun ló lọ́sà àwa lọ́lọ́run fún lóòótọ́ àwa lọ́lọ́run fún àmọ́ àwọn kan lọ́lọ́run gbé iṣẹ́ yẹn lé lọ́wọ́ mo máa fẹ́ kí àwọn ẹlẹ́gbẹ́ mi lórí nǹkan tó ti dábàá tó ti sọ sílẹ̀ pé àwọn agencies tó wà nídìí ọ̀rọ̀ yìí kí wọ́n tẹ ìwé pélébé fún wọn mostly Office of Drainage Services, Lands, Environment, Physical Planning gbogbo àwọn eléyìí lọ láti then olùdarí mo tún fẹ́ mẹ́nu bà ọ̀rọ̀ òjò tó rọ̀ kọjá yìí àwọn canals tó wà ní agbègbè wa ní Ìpàyẹ́ ní Agric àti Ìrà pátápátá ni omi wọ gbogbo àdúgbò yẹn àwọn agencies tó wà nídìí iṣẹ́ yìí náà olùdarí mo fẹ́ kí ilé yìí kó ràn wá lọ́wọ́ ó dẹ̀ ràn mí lọ́wọ́ because àwọn people yìí ọ̀dọ̀ mi ló ń wá lọ́wọ́ ń ké pé ká ran àwọn lọ́wọ́ kò dẹ̀ sí ọ̀nà tá lè fi ṣe dàn ká wá sọ iwájú ká wá sílé ká wá sọ náà ẹ ṣeun olùdarí.
wọn ò ní fẹ́ kí a túbọ̀ gbára wa lákòókò lórí ọ̀rọ̀ yìí a máa lọ síwájú máa lọ sí ẹ̀yìn nítorí a sì ní àwọn ìpele ìjíròrò tá a sì máa ṣe lẹ́yìn eléyìí máa ké pé aṣòfin Ishau kan túbọ̀ wá tan ìmọ́lẹ̀ sí gbàǹjarè tí wọ́n mú wá torí gẹ́gẹ́ bí ẹ ṣe sọ pé ọ̀rọ̀ súnkẹrẹ fàkẹrẹ ọkọ̀ wọ́n aṣòfin gbogbo pẹ̀lú wọ́n tún ìpolówó ọjà ẹ̀gbọ́n ti wà ní orí afẹ́ fi ẹnu kọ́ àwọn ìṣesí àwọn ará àdúgbò bẹ̀ gbàgbé wọn tó ń gbé àdúgbò àti àwọn tó kù àti ìjàmbá tó lè ṣe àdúgbò fẹ́rẹ́ pọ̀. yàrá aṣòfin Ishau.
olùdarí prayer ẹ ṣé olùdarí máa fẹ́ bẹ̀lẹ̀ abẹ́ aláṣẹ yìí pé kí bóyá kẹ̀dá ìgbìmọ̀ alábẹ̀ṣẹ́gbẹ̀lẹ̀.
mi ti béèrè àbáyín o.
mi ń gbọ́ yín dáadáa kí ni.
mi gbẹ́gbẹ́ ìmọ́lẹ̀ sí.
òkè sáwọn.
tún kọjọ́ lágbo ibi tí wọ́n ti ìtọ́.
ok ó ti yé mi sá. ọ̀rọ̀ méjì ló wà lẹ́sàn. ìkíní ń bẹ ọ̀rọ̀ omíyalé láti tó wá látọwọ́ pé à ń sọ omi dilẹ̀ ní etí ibi tí àgbàrá omi yẹ kó máa gbà sínú odò. àwọn àwòrán kan wà níbí tí mo ní fẹ́ pé wọ́n yà látòkè ó fi hàn pé wọ́n ti ń da yẹ̀pẹ̀ sínú omi yẹn wọ́n ti ń sọ omi yẹn dilẹ̀. nǹkan tí aṣòfin Ògúnkẹlú sọ tó tọ́ ni èmi náà rí lórí ayáramáṣá àbí alẹ́ tí wọ́n pè ayélujára tó ń pè ní íńtánẹ́ẹ̀tì pé wọ́n ti ń talẹ̀ náà wọ́n ti polówó ẹ̀ pé 1,000 square meters náà polówó síbẹ̀ 5.2 hectares lọ́tẹ̀ láwọn ní ìyẹn ti jẹ́ ká wá dúró ilẹ̀ tí wọ́n fẹ́ tọ́mi tán fẹ́ sọ dilẹ̀ mọ́tẹ̀ ṣe kan 5.2 yẹn kò ṣe pé gbogbo ẹ̀ lọ́mọ gbogbo ilẹ̀ yẹn kọ́ nìyẹn so ó láti tútù ju bẹ́ẹ̀ yẹn lọ. àwọn aráàlú tó wọ́n bá mi tó fi ẹ̀dùnnú wọn hàn ọ̀rọ̀ súnkẹfẹ́ fàkẹ́rẹ́ yẹn ó jẹ wọ́n lógún gan. Honorable aṣòfin Oyèkọ́nà sọ nǹkan táwọn rí ní àárọ̀ yìí súnkẹrẹ fàkẹ́rẹ́ yẹn bọ́n ṣe sọ 35 minutes ọgbọ̀n ìṣẹ́jú èèyàn ń lo wákàtí kan bẹ́ẹ̀ àwọn ará àdúgbò la mọ̀ pé à kì í gba ọ̀nà ọbẹ̀ yẹn a máa ń wá àwọn ọ̀nà kọ̀rọ̀ míì tí a máa gbà ní. Honorable aṣòfin àrò náà sọ mo ò rántí sọmọ́rọ̀ tẹ́lẹ̀ ni park view omi ń bá wọn jà ń bẹ̀yẹ̀ gan tẹ́lẹ̀ náà àwọn ẹlòmíì wọn láti wó ilé wọn balẹ̀ kan tukọ́ kó fi bọ́ sí ibi tí omi ò ní dààmú wọn mọ́. ẹ mọ̀ pé ó ní federal side ó ní tìjọba àpapọ̀ ó ní ti ìjọba ìpínlẹ̀ ibòmíì inú ibẹ̀ ti wọlẹ̀ wọ́n sọ pé ó ti lọ below sea level bí deputy chief ipa náà ṣe sọ. ọ̀nà tó jáde nínú estate yẹn kò pé méjì tó bá fi pé méjì wọ́n yà lọ́nu banana láti lọ jáde ni kò dẹ́ ṣe ọ̀nà tó fẹ̀ tó ju bíi ẹsẹ̀ bàtà 20 lọ tẹ́ pé mọ́tò kan lọ mọ́tò kan ń bọ̀ ló ń gbàgbé kọjá àwọn náà tún ní security ń bẹ̀ tó ń dáàbò bò wọ́n tó yẹ pé wọ́n ń ṣí ilẹ̀kùn fún wọn wọlé wọ́n ń ṣe ìtàwọn olóyìnbó ń pè ní access control tó bá di láàárọ̀ báyìí táwọn èèyàn bá ń jáde ẹlòmíì ò ń jáde kó ń lé ẹ o ní àárọ̀ kùtùkùtù ó máa ní sùúrù kí àwọn kan wọ́ lọ ni tó bá tún lọlé náà ó máa tẹsẹ̀ dúró díẹ̀ kó tó lọlé náà ni. nǹkan méjì yìí lásán báwo la ṣe sọ ní òyìnbó ó ń frustrate kí lẹ sọ ó ń fayé ni wọ́n lára bẹ́ẹ̀ ni ó kú dààmú bá wọn nínú ibẹ̀ yẹn mo mọ̀yàn kan tó tiẹ̀ ó tilé ẹ̀ pa ó kú òun bẹ́ẹ̀ torí àwọn ọ̀rọ̀ yìí mi mọ̀ bóyá mo ti sọ débi tí ẹ fẹ́ kí n sọ dé ọ̀gá kí lẹ wíṣà prayer mo máa bẹ ilé yìí ní abẹ́ àṣẹ yín sà pé báwọn ẹlẹgbẹ́ mi náà ṣe sọ kí bóyá lè dá ìgbìmọ̀ alábẹ́sẹ́kẹ́lẹ́ kan lẹ̀ kó pe gbogbo àwọn iléeṣẹ́ ìjọba tó ní ṣe pẹ̀lú ọ̀rọ̀ ilẹ̀, lands wà ń bẹ, new towns wà ń bẹ, PPP wà ń bẹ, physical planning ọ̀rọ̀ ilé kíkọ́ ní tiwọn, waterfront. Ṣùgbọ́n ọkọ̀ tó ṣe máa dákọ́ pé physical planning nígbà tí mo lọ wo bẹ̀ ẹnìkan tó ṣe títì sórí canal òun ti bẹ̀rẹ̀ sí kọ́ tiẹ̀ ó ti ń kọ́lé yẹn lọ, so ó dákọ̀ pé physical planning torí ibi tó ń ṣe yẹn nílá yẹn ọ̀tọ̀ ni àwọn kan tún ti ṣe kékèké sínú ọ̀rọ̀ bẹ̀ yẹn surveyor environment gbogbo àti tọ́ ìjọba ti tọ́ drainage service náà gbogbo àwọn tó ní ṣe pẹ̀lú ọ̀rọ̀ mo ti dárúkọ surveyor general kí gbìmọ̀ náà kọ́ pè wọ́n kí a lè kọ́ tọ́ná sí ìdí tẹ́lẹ̀ ìfiṣẹlẹ̀ àti gbogbo àwọn tó bá jẹ́ pé wọ́n ní ipa nínú ọ̀rọ̀ náà. Ẹ ṣé olùdarí. Mike. Bẹ́ẹ̀ni sà, ìyẹn náà ṣe pàtàkì. Àwọn tí kí àwọn tó fẹ́ máa talẹ̀ náà ká pe àwọn náà pé nǹkan tó rí àtàwọn tó fẹ́ máa rà náà ká ní kọ́ kéèsì àti olùdarí náà ká tún fi kún pé kọ́ lọ dá iṣẹ́ ẹ̀bẹ̀ yẹn dúró lẹ́sẹ̀kẹsẹ̀ báyìí nítorí gbogbo ọ̀rọ̀ tí a ti sọ nínú park view ló wà park view díẹ̀ náà wà ní banana ṣùgbọ́n ti banana yẹn dá pé federal government ló ní banana but nínú omi tó wọ̀ yẹn náà under drainage ni kò ń ṣe waterways because it's more bíi gọ́tà ló jẹ́ fún estate so actually pé àwọn náà torí inú gọ́tà náà wọ̀ kó ṣe waterways tó ká tí ọkọ̀ ń gbà lọ. ní kankan tí mo fẹ́ san nílẹ̀ sàpàmì lórí.
ṣé àbáyé ni ẹ̀ dá lóhùn.
bẹ́ẹ̀ ni mo dá lábàá mo ń gbìyànjú láti rò bóyá kò kún kankan ni àti sọ pé kán dá iṣẹ́ wọn dúró kán mo dá lábàá ẹ ṣe olùdarí.
àdéhùn kí àbá náà lẹ́yìn. àṣòfin kátó.
ẹ ṣe olùdarí mo dìde láti kí àbá náà lẹ́yìn.
ṣé gbogbo wa ló fara mọ́? ṣé gbogbo wa ló fara mọ́? àwọn tí ò fara mọ́ àwọn tó fara mọ́ ló pọ̀ jùlọ ní àtàrà ìdí èyí a yan àwọn ọmọ aṣòfin ilé ìgbìmọ̀ aṣòfin kí wọ́n ṣe ìjókòó alábẹ́sẹ́kẹ́lé lórí ọ̀rọ̀ tí a jíròrò tán tí a sì gbà wọlé yìí aṣòfin ìṣàwọ̀ wá ṣe olórí alága aṣòfin akínsànyà aṣòfin kẹ́hìndé joseph aṣòfin ògúnkẹlú aṣòfin àjọmálé aṣòfin ọ̀kánláwọ̀n aṣòfin ògúndípẹ̀ aṣòfin jubril abdulkarim àti aṣòfin Tèmítọ́pẹ́ Adéwálé. Akọ̀wé àgbà yan àwọn akọ̀wé àti àwọn amòfin tí wọ́n jọ máa bá wọn ṣiṣẹ́ pọ̀. A fún wọn ní ọ̀sẹ̀ méjì láti jẹ́ àbọ̀ fún ilé. Wọ́n dẹ̀ ṣiṣẹ́ náà ní kọ́mọ́kọ́mọ́ àti bó ṣe tọ́ àti bí ó bá ṣe yẹ. Akọ̀wé àgbà bá kọ ìwé pípèsè gbogbo iléeṣẹ́ ìjọba tí wọ́n dárúkọ láti wá rí ìjókòó alábẹ̀ṣẹ́kélé ẹ̀ṣẹ́. Àlàyé ara ẹni, àbọ̀ ìwádìí, ètò ìmúṣẹ́ṣe ètò ní lórí ọmọ ẹgbẹ́ tó pọ̀ jùlọ.
Ẹ ṣeun olùdarí àti gbogbo ọmọ ẹgbẹ́ ẹ káàsán. Ètò ìmúṣẹ́ṣe tòní, ìgbékalẹ̀ àbọ̀ ìwádìí. Àkọ́kọ́, ìwé ìfẹnúhàn tí àkọlé rẹ̀ jẹ́ fífi ọ̀nà ẹ̀rú gba ilẹ̀ ìwọ̀n 60 ékítà kúrò lọ́wọ́ ẹbí Ojackomo ti abúlé Sapata Ajiran tí ìjọba ìpínlẹ̀ Èkó ti yọ̀ǹda fún wọn tẹ́lẹ̀, àti gbígbé ilẹ̀ yìí fún ẹbí Ojomu ti Ajiran ní ìpàdé àpòpọ̀ pẹ̀lú àwọn òṣìṣẹ́ ìjọba ìpínlẹ̀ Èkó. Wọ́n ń béèrè fún ìwádìí fínífíní lórí ìwà àìtọ́ náà. Aṣòfin Adams, olórí ọmọ ẹgbẹ́ tó pọ̀ jùlọ. Ìkejì, ìwé ìfẹnúhàn tí àkọlé rẹ̀ jẹ́ ìtọ́kasí ìwà àìbófinmu, ìfipágbalẹ̀ àti ìgbésẹ̀ ṣíṣe ìforúkọ ilẹ̀ tí a mọ̀ sí púlọ̀tù 21 àti 22 ní agbègbè Jimoh Odutola estate Iganmu ní ọ̀nà ẹ̀rú láti ọwọ́ Vista International Company Limited. Aṣòfin Adams, olórí ọmọ ẹgbẹ́ tó pọ̀ jùlọ. Olùdarí, kí a lè ṣe ètò yìí kó lè múnádóko dáadáa, màá fẹ́ dá lábàá ní pé kí a so abala kejì ẹsẹ̀ 11 òfin ilé lórí ìlò èdè Yorùbá fún ìjíròrò ọjọ́ bọ̀rọ̀ láti fi èdè Gẹ̀ẹ́sì ṣe àwọn iṣẹ́ tí ó wà lórí ìwé ètò ìmúṣẹ́ṣe tòní. Mo dá lábàá.
Alórúfẹ́ gbẹlẹ́sẹ̀. Ọ̀pẹ́ aṣòfin Mọ́síbà.
Ẹ ṣe olùdarí, mo kí àbá náà ní ẹsẹ̀.
Ṣé gbogbo wa ló faramọ́? Àwọn tí ò faramọ́, àwọn tó faramọ́ ló pọ̀ jù.
Right, Honorable Speaker.
Majority Leader, before you write me, I think we need to be more, active with our rules. Yesterday, I think it was yesterday or day before yesterday, Bauchi, I think it was Bauchi House of Assembly that has adopted the Hausa language as the major language for deliberation and relegated English to the second. So if we have adopted Yoruba to be spoken on Thursday, and most times we still have to, step down the provision of the rules, I think we have to do something about it. So beside that, there is no printouts of Yoruba reports on these subjects we are about to do. So which means we are not prepared, we are not even ready, to use Yoruba today. So I think you should look at this properly and address it. It's not every time we come here on Thursday, we continue to step down our, what is it called? The provision of the rules in order to dump Yoruba. And that we've been emphasizing, we've been discussing, we've been raising regularly. So please take note of this. And Mr. Clark, to you as well. It's all right.
Well noted, Mr. Speaker, sir. Right, Honorable Speaker, distinguished colleagues.
For us to take these presentations, may I move that this House resolve to committee of the whole. I so move.
Honorable, yeah, I can see your light, but I can't see your face. So
Honorable Tijani.
Who?
Honorable Tijani.
Honorable Tijani.
Thank you, Right Honorable Speaker. I'd like to score the motion as moved.
All in favor say aye. Those against nay, the ayes have it. Only man Lord. Yeah,
okay. Thank you very much, sir. Report of the Committee on Judiciary, Human Rights, Public Petitions, and LSHA on a petition on fraudulent conversion and illegal reassignment of 60 hectares land, originally excised to the Ojackomo family of Sapata village, Ajiran, by the Lagos State Government to the Ojomu family of Ajiran land, in concert with top officials of the state government, demand for investigation, reversal of the fraudulent conversion, and unlawful reassignment and imposition of sanctions on the officials involved in illicit acts. With your kind permission, sir, can I move to submission, sir?
Yeah, start from 2.0.
Okay, sir. 2.0. The cross of the matter. The Ojackomo family land, known as Sapata village, form part of the Lekki Peninsula scheme, government revocation of 993, which was gazetted as number 20, volume 26 of 13th May 1993. After the revocation, the family applied for a village excision in 1998, which was granted by a publication of Lagos State Official Gazette, number 40, volume 40 of 31st May 2007, titled Sapata Village Excision of 50.47 hectares, C Annex 1. Surprisingly, the certificate of occupancy of the said excision was issued in favor of the Ojomu chieftaincy family, who intervened Surprisingly, the certificate of occupancy of the said decision was issued in favor of the Ojomu chieftaincy family, who intervened in the process and claimed ancestral ownership and overlords of both Sapata village and the Ojackomo family. This prompted the Ojackomo family to institute a legal action to redress while they applied for fresh excision to ensure that their ancestral presence on the land is not totally obliterated. The petitioner lamented that another 60 hectares, which was excised to the Ojackomo family, is also being intercepted by the Ojomu family in conjunction with some top government officials in the state who are frustrating his client's efforts at possessing the land, which was duly excised to them by the state government. They sought the intervention of the House for justice on the matter. 3.0 submissions. 3.1 Barrister GT Ogunye, the lead counsel to the petitioner, informed that the Ojackomo family are the aboriginal settlers of Sapata village, Ajiran, whose progenitors are mainly fishermen and farmers of ancient Ilaje ancestry. He posited that in addition to settling at Sapata village shorelines, the Ojackomo also purchased a large parcel of land covered by a survey plan showing property which form part of the excised land belonging to Pa Lawrence Ojackomo in plan number KESH/L/2211 dated 14th October 1982 from the Ojomu family. See family survey as Annex 2. He added that after the Lekki revocation of 1993, the family applied for a village excision and was granted 50.47 hectares alongside that of other village excisions.
officially gazetted and published as number 40, volume 40 of 31st May 2007, titled Sapata Village Excision. Copy of Excision Gazette as Annexure 1. He further informed that after the grant of the excision, the Ojomu family started laying claim to ownership and overlord of Sapata village, claiming that the Ojackomo family are tenants on the land and therefore not entitled to the excision. He described the Ojomu family intervention in the excision granted to the Ojackomo families as sheer annexation occasioned by greed in view of the fact that the Ojomu family was equally granted 2 excisions, namely Ayetoru and Barua village excision in the same gazette. See pages 291 and 293 of Annexure 1. He stated that when it became apparent that the Lagos State government was acceding to the claim of the Ojomu family over the excision, his client, Ojackomo, instituted a court action in the High Court of Lagos State in suit number LD/1170/2005 by Lawrence Ojackomo, head of Sapata village, Etiosa local government area, and 2 others versus Attorney General of Lagos State and 3 others, to seek declaration among other reliefs that the Ojackomos are the ones entitled to the grant of certificate of occupancy in respect of the 50.47 hectares size and released to Sapata village under the Lekki revocation of 1993. He submitted that judgment in the suit delivered by Honorable Justice Y. Udowu of the Lagos High Court in October 2017 did not favor his client Ojackomo, prompting an appeal at the Court of Appeal, Lagos, which held the High Court decisions in its judgment delivered by Honorable Justice Tijani Abubakar on 31st May 2019. A further appeal filed at the Supreme Court to overturn the decision is still pending. Barrister G.T. Ogunye further lamented that while the litigation and adjudication of the suit was ongoing at the High Court and Appellate Court, the Ojomu family has sold off the entire disputed 50.47 hectares of land to unknown persons. He added that in the realization of stalemating issues of ownership and beneficiary of the excised 50.47 hectares taken over by the Ojomu family, the Ojackomo family applied a fresh excision of the waterfront portion of their land to be sandfilled by dredging to ensure the preservation of the ancestral presence in the community. More so, to forestall another claim that Sapata village belongs to the Ojomu family. Which they used to hijack the initial 50.47 excision. The Ojackomo family described to use their family name to apply for the first excision, which the government graciously granted them 60 hectares of land, which was conveyed by the Office of Surveyor General of Lagos State via survey titled Ojomu Survey Plan number LS/D/LA/3834 dated 10th October 2015. See application and attached survey plan as Annexure 3. That just as they appropriated the previous 50.47 Sapata excision, the Ojomu family, in conjunction with some top government officials, has started intervening in the 60 hectares excision by writing petitions against the excision and attempting to snatch it just as they did with the initial land. See Ojomu's petitions against the excision as Annexure 4. This second hijack attempt, Imposition, prompted the Ojackomo family to engage Honorable Justice Oguntade retired as consultant to help them secure certificate of occupancy in respect of the 60 hectares excision. He lamented that Justice Oguntade tried unsuccessfully to broker a settlement between the two families over the matter. He reported that his client got privileged information that the state governor, Mr. Olusola Sanwo-Olu, had issued a certificate of occupancy to the Ojomu family in respect of the 60 hectares excision granted to the Ojackomo family. This certificate of occupancy, he maintained, was predicated on falsification of documents in a purported agreement between the Ojomu family, Ojackomo family, and one Abacop Properties and Co. Foliage Limited, in which the Ojackomo family acknowledged the right of the Ojomus to the 60 hectares excision and agreed that the title be changed to Ojomu Family Excision. He further informed that the document falsifiers are also purported to have resolved all litigations and adjudications in the previous 50.47 hectares out of the court, whereas the matter is still pending at the Supreme Court, and the appellant never had any meeting with his client to settle out of court. Barrister GT accused top officials of both the Lands Bureau and Office of Surveyor General of Lagos State of a grand scheme to rob the Ojackomo family of the 60 hectares excision by deliberate falsification of documents and misrepresentations that facilitated issuance of another survey plan in favor of the Ojomu family, on which the said certificate of occupancy was issued. He briefed the committee of the willingness of the Ojomu family to amicable resolutions of the matter brokered by Honorable Justice Oguntari retired, which had advanced to the signing of a memorandum of understanding between the two families, when some members of the Ojackomo family scuttled the process and initiated another petition which stalled the process. He countered Barrister GT Ogunye's claim that the Ojomu family falsified documents and forged the signatures of the Ojackomo family in the signed memorandum of understanding, and cautioned that the Ojomu family, headed by His Royal Majesty Oba Tijani Akinloye, is a respected family that cannot be condescended to such illegality. He tendered a copy of the said memorandum of understanding, which was co-signed by His Royal Majesty Oba Tijani Akinloye and Alhaji Yekini Bakari for the Ojomu family, while Mr. Olatunde Ojackomo and Mrs. Mojisola Adejimi Adeleye signed for the Ojackomo family. See copy of MOU as Annexure 4.0. Visit to the locus in Co. The committee, accompanied by officials of Land Bureau, Office of Surveyor General of Lagos State, and Lagos State Special Task Force on Land Grabbers, on Tuesday, 18th April 2023, paid a fact-finding visit to the disputed land behind Chevron Drive, Etiosa local government, where the followings were observed. 1. The entire area is heavily guarded by armed security engaged by Gracefield Island developers, who initially prevented the committee from accessing the road leading to the disputed area before the intervention of the security on the committee's team. 2. 50.47 hectares Sapata village excision has been completely sold out by the Ojomu family, who allocated the land to private developers. 3. Reclamation and dredging activities were ongoing in the area, as evident by heavy mining equipment and movement of sand laden tippers during the committee's visit. 4. The 60 hectares Ojackomo excision land extends to the river bank. 5.0 findings. The following observations were made by the committee in the course of carrying out the assignment. 1. The Ojackomo family has settled in Sapata village, Ajiran, from time immemorial, and also bought large portions of land from the Ojomu family. 2. The Lekki Global acquisition of 1993 affected part of Sapata village, in which the Ojackomo family has interest. 3. 50.47 hectares village excision was granted to Sapata village in 1995, but the Ojomu family intercepted the excision processes and claimed ownership of the excision, claiming that the Ojackomo family as customary tenants of the Ojomus. 4. The excision hijack was challenged both at High Court and Appellate Court by the Ojackomo family, and they lost. Final appeal is pending at the Supreme Court. 5. At the committee visit to the disputed area, the entire land has been allocated and built up by private developers. 6. Another excision of 60 hectares was granted to the Ojackomo family by the Lagos State government in 2015 and was also intercepted by the Ojomu family. 7. A memorandum of understanding between the Ojomu and Ojackomo families, brokered by Honorable Justice Oguntade, was duly signed by both parties but was not dated. 6.0 recommendations. Based on the available documentary, oral and written submissions, the committee hereby recommends that the Ojomu family and Ojackomo family revert to the memorandum of understanding
brokered by Justice Adeshola Oguntari retired, and duly signed by both parties, wherein it was agreed that the land be shared in ratio of 52% and 48% respectively as final settlement in the interest of peace. Conclusion. The committee expresses gratitude to Mr. Speaker and members for the opportunity given to it to carry out the assignment. In the same vein, appreciation also goes to the clerk of the House and staff of the committee for ensuring that the job is completed satisfactorily. Thank you very much. Honorable Barrister Akonde Vio, Chairman, Committee on Judicial Human Rights and Public Petitions. Okay. Oh, sorry, sir. I think there was an omission on the printout where Mr. Bodiagoro. Can I please read that, sir?
Yeah.
Okay. 3.2. Mr. Bode Agoro, the Permanent Secretary, Lands Bureau, in his response, informed that the state government recognized the Ojomu of Ajiran as the paramount ruler of Ajiran land, and that Sapata village excision, like others in the area, was applied for by the Ojomu family. He stated that the initial 50.47 hectares Sapata village excision was granted to the Ojomu family because it is on record that Sapata village and the Ojackomos were tenants of the Ojomu family since 1929, and that excisions are not granted to tenants without the approval of their overlords. He also cited the tenancy receipt which the Ojomus presented at the appeal court during the litigation as evidence that a landlord-tenant relationship existed between the two families. On the claim that the Lands Bureau is involved in a grand scheme to rob the Ojackomos of their excision, Mr. Bode Agoro informed that excision processes are deemed concluded and finalized only when an official gazette has been issued in respect of that application, which was not followed through by the Ojackomo family. He further informed that his office is aware that a truce arrangement was being brokered by Honorable Justice Oguntade between the two families, but denied complicity of Lands Bureau in the process, as excision involved multiple agencies like the Office of Surveyor General, Lands Bureau, Physical Planning, and Ministry of Justice, among others. 3.3. Honorable Jide Akinloye, who represented the Ojomu family, admitted that the Ojackomo family had lived many years in Sapata village, but that they do not own any piece of land in Ajiran or Etiosa community. He insisted that the Ojackomos are customary tenants of the Ojomu of Ajiran land, who paid ground rent and tributes to the Ojomus and are therefore not entitled to claim the excision. According to him, the lordship of the forefathers of Ojomu family over the Ajiran land and Sapata village was strengthened by the judgment of High Court of Lagos State in suit number LD/1170/2005, instituted by the Ojackomo family and upheld by the appeal court. Okay. He briefed the committee of the willingness of the Ojomu family to amicable resolutions of the matter brokered by Honorable Justice Oguntade retired, which had advanced to the signing of memorandum of understanding between the two families when some members of the Ojackomo family scuttled the process and initiated another petition which stalled the process. He countered Barrister GT Ogunye's claim that the Ojomu family falsified documents and forged the signatures of the Ojackomo family in the signed memorandum of understanding, and cautioned that the Ojomu family, headed by His Royal Majesty Oba Tijani Akinloye, is a respected family that cannot be condescended to such illegality.
This point now. Why are you taking?
Okay.
You have read this, and why are you bringing the report in piecemeal?
In the course of collision, sir. Sorry about that, sir. They missed out the date, sir.
Can you put off your light? Honorable Afini.
Thank you, Mr. Speaker. I move that the report as presented be adopted for debate.
Who is seconding? Honorable, take this.
I second the motion as moved.
Tijani, how come your own light is coming? It's attached to your.
I have to transfer it from that
office. It's using his office. Honorable Tijani.
Thank you, right honorable speaker. I second the motion as moved.
All in favor, say aye. Aye. Those against nay, the ayes have it. Yeah, who goes first? Honorable, can you do the same?
Thank you, the right honorable speaker, and I want to appreciate the committee chairman for the presentation. But I have some observations in respect of the presentation and the recommendations that has to do with number one. There was a Supreme Court, they said they have a Supreme Court hearing in respect of the case. So the committee silence about it. We don't know the outcome of that one. And secondly, the recommendations given by the committee that has to do with the broker that Justice Adeshola Buntade brokered with them, we did not see the copies of that.
It's not attached.
Yes, it's not attached for us, so that we will be able to deliberate upon it. Thank you, sir.
Deputy Speaker.
Thank you, Mr. Speaker. I would also like to appreciate the committee for a thorough job well done. However, on page 3, it stated there that the matter is already in court and first judgment, second judgment has been given. So both parties are also waiting for, I want to believe, the final judgment from the Supreme Court. So on that note, I would want to suggest maybe two things. It's either they settle out of court or wait for the Supreme Court judgment. Secondly, sir, on page 6, it was also written that signatures were forged. I want to believe there is a say that says he who alleged must prove. Do they have the forensic proof that signatures were forged, or it was just an assumption? Lastly, sir, part of the report also stated that there was an MOU, standing MOU, but not dated. To me, I don't see that as being something tenable anyway. If you have an MOU without a date, I don't think that's going to be accepted anywhere on this particular matter. Thank you so very much, sir.
Honorable Tijani.
Thank you, right honorable speaker. I want us to remember that these two family, their case is still remaining in the court, even up to Supreme Court, and the judgment does not favor Ojackomo family at the High Court and at the same time at the Appeal Court. And I don't think this house can settle anything out of that unless they settle that matter out of court. And two, it was indicated that out of the findings, the Ojackomo family had settled in Sapata village, Ajiran, from time immemorial, and also bought large portion of land from the Ojomu family. So it is really clear, and I think this is the reason why the judgment does not favor Ojackomo family at the High Court and Appeal Court. Thank you, sir.
Honorable Akola.
Thank you, Mr. Right Honorable Dr. Mudashiru Ajiayobasa. My understanding of the findings of the committee is that we have two issues at hand. One of 50.47 hectares of land,
which was granted excision to Ojackomo, and which is in court, in the Supreme Court. So I'm wondering if it will not be sub judice for us to, you know, to intervene in that matter. Secondly, under the findings, number 6, there is also this issue of 60 hectares, which was also granted to Ojackomo family, but intercepted by Ojomu family, of which Justice Ogutade has intervened, has brokered settlement amongst the family of Ojackomo and Ojomu family, of which a memorandum of understanding was duly signed by the two families. So it's neither here nor there. Therefore, I want the committee chairman to further explain this to us before we conclude. Thank you, sir.
Honorable Ajadu.
Thank you, Mr. Chairman. Just two things I'd like to clarify in the report, sir. Number one, I'm not exactly clear, based on the information provided, what proof either family have as to whether they are the tenants or the landlords of the said property in the initial 50.47 hectares excision. On the second question is about the 60 hectare excision. What claim does the Ojomu family actually have that they are stating that they are able to remove the excision from the Ojackomo family? What proof do they have for them to make that statement that's allowing them to fight them in court? Thank you.
Both of your lives. Who has the right?
Good afternoon, right honorable speakers, distinguished colleagues. I think this matter is straightforward. The matter is still at the Supreme Court, and according to the law of extant law of the Federal Republic of Nigeria, I think all parties need to understand and maintain caution until Supreme Court passes judgment on this matter. And another observation I have with this report is that whenever the committee of the House has the oversight functions to visit any public or private property, we must introduce an act that may not hinder our members from carrying out their oversight function. Because in line with this report, it was stated that initially security operative, whether private or public, disturbs our member. I think this should be put to and even the Surveyor General has even gone further by stating the right of the Ojomu family and the Ojackomo family by saying once is a tenant to one, but I think Supreme Court has the final judgment on this. Thank you.
Honorable Lara. That's where they will give you mind statement.
Right Honorable Speaker, sir, and distinguished colleagues, I want to chip in a bit of point on what Honorable Ajani said earlier about the land. And because we have 2 cases on ground, that's 50.7 hectares of land and 60 hectares of land. So knowing that the indigenous families in Lagos and the Land Use Act, I believe that the Indejos are the only families in Lagos. And the Ojomu family is an Indejo family. So I'm not surprised from this report that we have the occupants of the land and it was in their name from the state government, because obviously it's something that is very clear. I don't need to, people from, if you know the real story of land and how you can collect your land allocations and documentations from the state government, usually the Dejo owning families in Lagos, who are the land owning families, are the ones that can collect the documents from the government to give it to their tenants or whoever they want to sell it to. Thank you very much.
Honorable Ishao. Sorry. Who has the light, sir? Okay. Honorable Shehu.
Thank you, Mr. Speaker.
Yeah, go ahead.
I think this report is very clear. First, let me thank the committee for their recommendation. It's just a matter of a landlord and a tenant, the way I'm looking at it. Because Ojomu family, everybody knows Ojomu family as the owner of mostly the lands at Ajiran and environment. And Ojackomo family knows that in these reports, as you can see, that Ojomu family has won at the High Court and Appeal Court, and I think they know that Ojackomo family knows that there's no way they will win at the Supreme Court, and that's more reason why I think they are crying out now. And I believe with this recommendation, if there's a way they can settle out of court, it will be better than them going to the Supreme Court, because they can never win since they are tenants, and there's a tenant agreement since 1929 according to the report, and there's no way I think they will be able to overturn at the Supreme Court. So thank you, Mr. That's my own contribution. Thank you, sir.
Number one, let me raise the issue that majority leader. Okay, Rabusha, you still want to say something?
Go ahead. Okay, thank you, Mr. Speaker. I would just like majority leader to shed light on a couple of things. One, the recommendation that has been made, which is that 52%, 48% as the case is, based on a document that is not signed, even though we can see that the seal of the lawyer there says valid till 2020, March 2017. But my concern really is on page 4. Unless maybe something is missing here. If you permit me to read, I went further to say, family to engage Honorable Justice Odutola retired as consultant to help them secure certificate of occupancy in respect of the 60 hectares. Of course, we know there's the 50-something and the 60 hectares. He lamented that Justice Odutola tried unsuccessfully to broker a settlement between the two families over the matter. Yet, we are saying that there's a document signed by the two parties on the sharing form. I would like him to just shed some light on the extent of that agreement. Thank you, sir.
Majority leader.
Thank you very much, sir. I'd just like to say that even Honorable Jide Akinloye has already said that they are also willing to settle out of court. And what this report is saying that there was a memorandum of understanding between both families, which was brokered by Honorable Justice Odutola, and it was really signed. When we talk about the date, if you look at the memorandum of understanding, there's a particular place that you will see a signature, which is 6/12 sorry, 6/12/2000. There is a date. The memorandum of understanding is dated. There is a date there, but I couldn't read it out because of this printout. There's a date there. But all I want to say is that both parties are willing to settle, and they have signed memorandum of understanding. Even Kabiyesi, His Royal Majesty Obatijani even signed the memorandum of understanding. And this family, they giving them land for the first time. It was taken over by the Ojomu family. They went to court. The Ojomu family won. The appeal court, the Ojomu family, they won at the appeal court. But the case is still pending in Supreme Court. But both parties are willing and ready to settle, and that's why they signed this MOU. So I will still say that our recommendation is still in course, in as much as the Honorable representing Honorable Jimoh has said they are willing to settle. And the Ojackomo family too, they are willing to settle. And there's a settlement, 52% and 48%. So I think this our recommendation is still in course. On the case of the issue of something that is in Supreme Court,
the issue is still in court. What are you saying?
What I'm saying is this our recommendation is still okay. It can still be adopted as our resolution of the House. In as much as both families are willing to settle and they have agreed to settle. So if we take this resolution now, they can settle out of court. They are willing to settle. That's why they did a MOU 52% and 48%, which was duly signed by both parties. Their signatures are there, and there's a particular date that was signed by a witness. Even Honorable Justice Oguntade too, retired, also signed the document, sir, the MOU.
But the parties to the matter have not signed. None of them are signed. None of them are signed. Well, let me start.
Sir, their signatures are there, sir. The Ojackomos too, sir. They signed too.
Both they signed.
Yes, both parties signed, sir.
Yeah, but what you have in your reports is quite different from the annexed attached. In your presentation, you said they have not. They did not sign. That was what you said. Go through your report. That was what you said. That they did not sign. If I'm correct. But
sir, both parties signed, sir.
My friend, don't interject.
Yes, sir. Yes, sir.
Well, that was what you said when you were presenting your report. But from the honesty of the document you attached, you said both of them have signed. I said, and even from the account of Honorable Jide Akinloye that represented the Ojomu family, said they were ready. That they were ready. So, which simply means what you read does not comply with what you attach, because if they have signed and you have the document, you attach it already. It's just to go straight to the point that and the both parties have signed. The simple as that. So most of the questions being asked will not have come up. Will not have come up to address. But one other thing I want to say is that the chairman of the committee that prepared the documents, report, is no more with us. So this started from the Ninth Assembly. So it's just taking charge to follow up on the report. So the majority leader. So that should be considered, as he may not have the full knowledge of the whole deliberation. It's just relying on the report as being prepared by the chairman, former chairman of Judiciary. Honorable Afeni, your line was on.
Yes, sir, Mr. Speaker. I just wanted to buttress what you are saying. However, it was said that a document existed, the MOU, but Barrister GT Ogunye from the Ojackomo family, their lead counsel, said that the signatures were falsified. So I don't know how the committee certified if the signatures are real or not, if the committee looked into that.
Honorable Baba.
Thank you very much, Right Honorable Speaker. Three things at stake here. The governor withdrew the CFO from Ojackomo and gave it to the Ojomu. The memorandum of understanding.
Which one we are talking about?
To the land, the 6 by 6,
the 60.
Yes. Okay. So he withdrew and give it to Ojomu, first in line. And then the second thing, the Supreme Court judgment is still waiting. Justice Oguntade, the memorandum of understanding has not clearly shown that the two parties are ready to settle out of court. And if they are ready, then they should have written Supreme Court, and that should have been settled. So the issue of 50.
No, don't go there. You can, while your case is pending in court, you can also employ settlement. So it is allowed. It depends on the outcome of such document. And let me also add this: from discussing issue before the courts, I think it's divided into two. It's divided into two. It's for you not to go into the nitty-gritty of the litigation that is possible to influence the outcome of the court, but where it is necessary, you can still address part of it. So you can't say because we have a case in court, fine, that we cannot address important aspects of it, but we cannot, make incursion into the decision of the court that can probably influence what the outcome of the litigation will be. I think we have a lot of confusion on this report. If GT, who is representing the other family, claim that the signature on this, what is it called?
It's false.
MOU was forged, and we do not have the, counter reports or response as to the forgery aspect of it. So I think now Honorable Jimoh.
They ask the member of the committee if there is any of them that still available among us here, can put more light on how far they have gone to find from the signatory. Are they really the one that signed the document or not, so that from there we can know the genuinity of the signature. If they were duly signed by them, then we can now agree that okay, what they have really done is genuine, because some are saying it's forged, while some are claiming that they have agreed on the outcome of their meeting.
No one has said they agreed. The representative of Ojomu only said they were ready. So, I only said they were ready, so we cannot actually base judgment on Honorable. Can you do yourself? Can you put your...
Thank you, the Right Honorable Speaker. The cases here are two cases. The first one has to do with 50.47 hectares.
I don't think that is in contention.
Yes, the other one on this 60 hectares.
60, yeah.
That was the one that the Honorable Justice Oguntade have been able to broker peace with them. Yeah. And at the committee, those people even said it on their own that they are ready to broker the peace in respect of this agreement of 52% and 48%. And sincerely speaking, has been said by the majority leader, I think the recommendation is based on what the two groups agreed upon. Then that was what the
what is it called? The lawyer of the other family claimed that it was forged. So that is the question. Honorable Shaw.
Thank you, Mr. Speaker. Well, like I asked earlier on, and thank God, Mr. Speaker, you have also alluded to it. The narration within the body of the finding of the report does not really point to an agreement. For instance, there's a stamp on this document, even if you say we can't find the date, that says valid till March 2017. If this agreement had been in place since 2017, I don't know why they're still arguing over it here. Then, like you said also, we can't see any commitment from both parties now that they are ready to go by this agreement. And if you look at this memorandum, sir, There are two matters here. This memorandum does not speak specifically. I mean, we can't see 60 hectares, we can't see 57 hectares. It could easily be another parcel. There is nothing in this document that raises that recommendation.
Yeah, thank you, my colleagues, for your contribution. In view of what in view of observation made by my colleagues from the report presented by the majority leader, I hereby rule that the report be stepped down and give the committee that right to reinvite all parties involved to get clear position of their settlement. Yeah. The next report. Majority Leader.
Yeah, thank you very much, sir. Reports of the Committee on Judiciary, Human Rights, Public Petitions, and LSHA on the petition titled Illegal, Unlawful, and Forceable Land Grabbing, an attempt at fraudulent registration of land known as Plot 21 and 22 at Jimoh, Odutola Street, Iganmu Industrial Estate by Vista International Company Limited. It's your kind permission, sir. Should I move to, can I move to 3.0 submission, sir? 3.0 submission, 3.1. Okay, 2.0, yes, sir. Matters arising. The petition from Barrister Ojackomo and Co. on behalf of Mid Motors Nigeria Limited, owned by Chief Gabriel Osawaru Igbinedo, borders on the ownership of a disputed parcel of land at Iganmu Industrial Estate between his client and Vista International Limited at Jimoh Odutola Road, Iganmu Industrial Estate, Apapa Itato, occupied by Mid Motors Nigeria Limited on lease from the Lagos State government for a period of 50 years since 1970. On the other hand, Vista International Limited claimed that the Lagos State government had allocated the land to it after payment of statutory charges in 2021. The tussle started in 2009 when Vista International, a corporate neighbor on the same street, which had mutual understanding with Mid Motors to park his trucks on the disputed land, purportedly started laying claims to ownership of the land, which it, Vista International, claimed had been duly allocated to it. According to the petitioner, Vista's claim was tacitly supported by the Ojara chieftaincy family, who demanded ratification following a Supreme Court judgment in their favor against the Lagos State government over the entire Apapa and Iganmu land settlement. The petitioner sought the intervention of the House to prevail on the state government to redress the illegal allocation of land to Vista International, because the Lagos State Lands Bureau did not give his clients, Mid Motors, who had possessed the land for 50 years, and notice of revocation of the existing lease agreement, nor was he availed the benefit of forced reversal before reallocating the land to Vista. 3.0 submissions. 3.1. Barrister Ojackomo, counsel to the petitioner, Mid Motors Nigeria Limited, informed that the land in contention, plus 21 and 22 Jimoh Odutola Road, Iganmu Industrial Estate, Apapa, which has served as the corporate headquarters of his client, Chief Gabriel Osawaru Igbinedo, for almost 50 years, has suddenly become a land in forceful occupation by Vista International Limited, an Indian company with the support of some unknown top government officials. He explained that Mid Motors has a land certificate number MO11707 bracket equivalent to CFO, then issued by the Lagos State government through its Lagos State Development and Property Corporation Agency in 1976 under a 50 years lease agreement, and that the certificate was lodged with the State Lands Registry. See land certificate as an extra form. He further stated that the land in contention has never been vacant, even when his client relocated to Benin City, Edo State, after he established Igbinedo University in 2005, as the property was rented out to Cadra Enterprises Limited, a paper packaging company, to manage the property on his behalf. See lease agreement with Cadra as Annexure B. He posited that when Cadra Enterprises, its client's tenants on the premises, started having issues with Vista International Limited over ownership of the premises, which ended at the High Court in suit between the duo. His client sought to be joined in the suit to set the record straight, but the case was eventually settled out of court at the instance of the Ojora of Ijora, who pleaded on behalf of Vista International that Mid Motors should allow Vista to use part of his premises temporarily as a parking lot free of charge. He further informed that after the Supreme Court judgment in favor of the Ojora chieftaincy family over the land, his client paid the sum of 25 million naira as ratification to the family to lease same portion to Mid Motors in order to avoid constant harassment and repossession threats from the Ojora family. Unknown to his client that the Ojora family was negotiating holistic settlement with the Lagos State government following the Supreme Court judgment. See payment proof as Annexure C. He lamented that unknown to his client, both Vista International and Chief Vitalis Ibe, Cadra Enterprises Managing Director, his client's tenant, had advanced the Ojora chieftaincy family 10 million naira each as payment for the purchase of the land immediately after the Supreme Court judgment on the matter. Hence, they are locus of claims to the property. See Cadra payments to Ojora family as Annexure D. He stated further that upon this discovery, Mid Motors terminated the tenancy agreement with Cadra Enterprises via an eviction notice dated 30th January 2017. See Annexure E, and reported the matter to the Lagos State Special Task Force on Land Grabbers to forestall any further illegal possession of their property. He further informed that when his client noticed some unusual movement of trucks and construction equipment on the premises, they thought it was Vista International Limited, whom they have mutual agreement with, to park its trucks in the premises, but that his client was surprised to discover that Vista International had registered another company, Avianto Nigeria Limited, which they, Vista International, initially claimed to know nothing about and had started demolishing Mid Motors warehouse and office complex on the premises to pave way for a new development, claiming that the land had been allocated to them by the Lagos State government. He further posted that before they realized what was going on, Vista International had used its newly registered company, Avianto Nigeria Limited, to apply and secure a certificate of occupancy registered as number 2 on page 2, volume 2021, E-COFO of Lagos State. See copy of COFO as Annexure F. He described the reallocation of the land to Avianto Nigeria Limited, while his client's lease agreement subsists without consultation or any right of first refusal, as an act of official land grabbing aided by some unknown top government functionaries in the lands bureau. He saw the intervention of the House and pleaded with the committee to redress this illegality by prevailing on the Lagos State government to expel both Vista International and Avianto Nigeria Limited from the land and return same to his client, in addition to payment of compensation, reinstatement of his client's warehouse and office complex demolished to pave way for their construction. 3.2. Barrister Olusegun Shipeolu, counsel to Vista International and Avianto Nigeria Limited, in his response acknowledged the relationship between one of his clients, Vista International, and Mid Motors over the years as corporate neighbors, and posited that Vista International is not a party in the disputed land in question, as it occupies plot 20, Jimoh, Odutola Street, Iganmu Industrial Estate, Apapa, with certificate of occupancy which is different from plots 21 and 22 on the same Iganmu Industrial Estate, which is in contention, and wondered why the company should be joined in the petition. He therefore pleaded that the company be absolved and discharged from any involvement in the matter. On the contentious clause 21 and 22 at Jimoh Odutola Street, Iganmu Industrial Estate, Barrister Shikoroolu affirmed that the land was duly allocated to Avianto Nigeria Limited by the Lagos State government, having fulfilled due diligence which involved payment of all necessary land charges totaling 646,303,775 naira. In addition to the commitment of other huge financial and material resources for the building of a factory on the premises. See land payment receipt as Annexure G. He denied any involvement and knowledge of his client about the mid-motors expired lease agreement with the Lagos State government and other issues with the Ojora Chieftaincy family over the land, and added that Avianto Nigeria Limited is a law-abiding corporate company who applied for land allocation like any other entity and was duly obliged by the state government. On the alleged demolition of mid-motors warehouse and offices on the land, Barrister Shikoroolu maintained that Avianto applied and got the necessary government approvals to build on the property, including demolition permits, development permits, authorization to commence construction and piling works, and safety compliance permits. See all permits as Annexure H. He urged the committee to discountenance the petition for lacking in merit. 3.3. Barrister Ejiro Ogbekone, counsel to Ojora Chieftaincy family, proceeded that the land in dispute is a matter for determination by the Lagos State government to ascertain the right allotee of plots 21 and 22, Jimoh Odutola Street, Iganmu Industrial Estate, in contention. According to him, the Ojora family, being represented by His Royal Majesty Oba Fatai Aremu Aromire, has no interest or roles to play in determining who owns the land and is not averse to peaceful and quiet possession of the property because the family did not allocate the land to any of the parties. He, however, admitted that Avianto Nigeria Limited approached his client to inform him that the land in contention has been allocated to their company out of respect for the royal stool. 3.4. Mr. Bode Agoro. The Permanent Secretary Lands Bureau corroborated Barrister Okafor's claim that the land was actually allocated to mid-motors for a time of 50 years, commencing from 11 February 1970, as stated in a registered lease agreement, but that it has become imperative for the state government to reallocate the land for meaningful development after the lease expired. He informed that the land was allocated for the purpose of assembling motor vehicles and motorcycles as stated in the clause 4D of the lease agreement, but that it was lying fallow and underutilized on the expiration of the 50 years granted. This, he stated, negates clause 7B of the lease agreement, which he read out that if the premises demised shall remain undeveloped for 3 years from the date hereof, then it shall be lawful for the lessor at any time thereafter to re-enter upon the demised premises, and thereupon this demise shall absolutely determine, but without prejudice to the right of the lessee, to a refund of any advance rent paid beyond the date of such re-entry. In addition, he revealed that available records in Lands Bureau indicated that mid-motors refused and neglected to pay mandatory annual ground rent, which is statutory obligations and requirement for leasehold renewal, whether demanded or not, as stated in the lease agreement in clauses 4F and G and 7A. He further informed that mid-motors did not indicate in writing or otherwise any interest for renewal the lease for 1 year or 6 months before the expiration of the term granted as stated in clause 5 of the lease agreement. Hence, the land became vacant after the expiration. See copy of lease agreement with mid-motors as Annexure I. He confirmed the allocation of the premises to Avianto Nigeria Limited after the expiration of the lease agreement with mid-motors, and that the allotee has paid the requisite fees of 646 million 303,775 naira to the coffers of the state government, and has been issued with electronic certificate of occupancy registered as number 2 on page 2 volume 2021 accordingly. See copy of ECOFO as annexure F above. 3.5 Visit to the locals in Quo. The committee in company of the Office of Surveyor General, Lands Bureau, and the Special Task Force on Land Grabbers embarked on an on-the-spot assessment tour of the disputed land on Wednesday, 11 January 2023, where the followings were observed. That 1. Rubble of demolished fence was evident at the site when the committee visited the locals in Quo. 2. It is evident that Meat Motors had relocated its operational headquarters from the premises elsewhere, as there was no official presence of the company on ground when the committee visited. 3. Vista International is a corporate neighbor of Meat Motors, and they both had understanding to allow Vista park its truck on the contentious property. And 4. The land was visibly vacant and left unused when the committee visited. 3.6 Observations. From the oral and documentary presentations by the concerned parties in dispute, the committee observed the followings: that 1. Meat Motors Nigeria Limited was the first in time on the contentious land and had a 50 years lease agreement with the Lagos State government, which expired in 2020. 2. While the lease agreement was signed in 1976, it was backdated to take effect from 1970, and both parties, Lagos State government and Meat Motors, appended their signatures, making it binding on both parties. 3. Meat Motors did not pay ground rent on the land for most part of the 50 years lease, contrary to lease agreement. 4. Meat Motors did not apply for renewal of the lease upon expiration. 5. Ajiran Nigeria Limited, as an offshoot of Vista International Limited, was duly registered and acquired the contentious land from the Lagos State government on lease following the expiration of the lease agreement with Meat Motors. 6. The land was reallocated to Avianto and issued a certificate of occupancy after payment of over 646,303,775 naira to the coffers of the state government in 2021. 7. Avianto Nigeria Limited got necessary approvals, including demolition permit from the state government, before removing encumbrances on the land. And 8. The Lands Bureau did not oblige Meat Motors the right of renewal or benefit of first refusal before reallocating the land to Avianto Nigeria Limited. 4.0 Recommendations. In view of the above oral and documentary submissions, the committee hereby recommends as follows: that 1. Meat Motors Nigeria Limited should forward an official application to the Lagos State government for land allocation elsewhere in lieu of the expired lease. 2. In view of its ongoing standing relationship with the Lagos State government, the Lands Bureau should allocate another land of commensurate value to Meat Motors, provided the company is prepared to meet the financial obligations and other conditions on same. 3. The Avianto International Limited should pay adequate compensation for the demolished fence of Meat Motors Nigeria Limited. Conclusion. The committee expresses its gratitude to Mr. Speaker and members for the opportunity given it to carry out the assignment. In the same vein, appreciation also goes to the clerk of the House and staff of the committee for ensuring that the job is completed satisfactorily. Thank you, Honorable Barrister Akondebi, Chairman Committee, Judiciary and Human Rights. Thank you, sir.
Honorable Tijani.
Thank you, Right Honorable Speaker. I move that the report of the committee should be adopted for deliberation.
Who is second? Honorable Lumo.
I move to second the motion as well.
All in favor say aye. Those against no, the ayes have it. Yeah, who goes first? Well, I think this is a very straight report, and the position of the committee has, I mean, the recommendation has also decides what to be done on the reports. But I think I have reservation on 2, 3 of the reports. Why do you want to ask the state government to consider mid-motto for another allocation when he did not even fulfill righteousness in the first allocation? He did pay land ground rent and he abandoned the land. So why are you soliciting for something that is not right? And the first you talk about, why do you want Aviato International to pay compensation to who? To who? He owns the land now, so it's not justifiable. It's totally unnecessary. So I think it's just to let go and forget. I think there's nothing in this report that warrants any recommendation further that Midwater should forward an official. Well, if Midwater wants to seek for allocation, fine, you can do that, but we cannot compel the state government to allocate. Why do we have to? On what ground? There's no basis for it. There's the one they allocated. Well, and even I think there's something that was left out in this report. When you lease a land, you have right to sublease again. You have such right. So I don't think it's necessary, but there's something funny about these reports, and that has to do with the Ojora person. The KBC collected from the right and the left. And he exonerated himself that it was just approach to the palace. Well, just Ojora, why call? So I don't see anything in this report. It's just let go. It has been resolved already, so it's just we should just let go. So nothing in this report. Yeah. Honorable Council.
Thank you, Mr. Speaker. I hereby move that the recommendation of the committee be adopted as the resolution of the House as amended by Mr. Speaker. I so move.
Yeah, Honorable Tijani. I support the motion as moved. All in favor say aye. Those against no. The ayes are it. Majority leader. Majority leader.
Right Honorable Speaker, distinguished colleagues, I wish to move that this House reverts to plenary. I so move.
Honorable Obafemi.
Thank you, Right Honorable Speaker. I want to second the motion as moved.
All in favor say aye. Those against no. The ayes have it. Majority leader.
Right Honorable Speaker, distinguished colleagues, at the Committee of the Whole, 2 reports were taken. One out of the reports was stepped down for another day, while the second report was adopted as resolution of the House. That was what happened at the Committee of the Whole, sir. Thank you, sir.
Thank you, Right Honorable Speaker. I want to say that as the true reflection of what transpired. Thank you, Right Honorable Speaker. I want to reaffirm that as the true reflection of what transpired at the Committee of the Whole.
Honorable Kennedy Joseph.
I rise to second the affirmation.
All in favor say aye. Those against no. The ayes have it. Majority leader.
Right Honorable Speaker, distinguished colleagues, Order 11, Rule 11 of the Rules and Standing Order of the House on the use of Yoruba language be resuscitated. I so move, sir.
Thank you, Right Honourable Speaker. I support the motion as moved.
In favor, say. Those name the ayes have it. Majority leader.
Olùdarí àti gbogbo ọmọ ẹgbẹ́, mo ní àṣẹ láti ọ̀dọ̀ olùdarí ń pé kí a sún ìpàdé yìí dìgbà tí tábà tún máa pè wá padà. Mo dá lábàá.
Ẹ ṣe olùdarí, mo dìde láti kí àbá náà lẹ́yìn.
Ẹ ṣe ẹ̀yẹ́lẹ́gbẹ́ bí a kú iṣẹ́ takuntakun. Àbá tí wọ́n dá láti lè fún àwọn òṣìṣẹ́ ìdè láti ṣe àtúnṣe gbogbo ẹ̀rọ àgbo àti àwọn mìíràn tó ń ṣe nínú yàrá òṣìṣẹ́ ìdè kankan wa ní àbá tí wọ́n mú wá ìpàdé ìjókòó yìí. Nídìí èyí ṣé gbogbo àti alábọ́ àbá tó dá àwọn tí ò fara mọ́ àwọn tó fara mọ́ ni ó pọ̀ jùlọ àsún ìjókòó ilé síwájú títí di ìbálò mo gbéra.